Jā, paldies par garo un smalko uz.
Thank you very much for this very lengthy introduction, which actually does not diminish the stress level. Part of the reason for my stressful day, because this year I have a mission impossible, because last year usually in this seminar we are not speaking only about IP case law, ECJ case law, also our neighboring country case law, but also on Latvia's case law. And the last year has been very fruitful, very rich with cases that we've dealt with, very complicated cases, almost all of them has several law issues, even something, some 11, 12, 15 laws can be applied. So what should I choose? 1, 2, 3 cases, but I have to come up with an overview. So I will give my presentation. It will be in written. It will contain 36 slides. I will not speak about all of those, but you will have the materials. And you, if needed, can refer to the judgments. I will not read the slides, but I will give you the main ideas. I've chosen 5 cases. One case will only be mentioned in order to understand what question was dealt with, but on 4 cases I will comment. One from decision from district court, because according to our process, it cannot reach Senate right away, but it is very important question, also on EU level. 2 other cases will be Senate, civil department cases, and 1 administrative department case, which is also very interesting. And my colleagues from this department said that the next similar case is already awaiting them. So these issues will be dealt with in the future as well. So first, decision from December from Riga District Court. And the question is whether it is the breach of related rights, and whether the fine should be paid for the apartments rented on short-term rent. So the claimant was the claimant was collective organization of related rights, and the defendant was a short-term leaser who offered an apartment or 3 apartments with Wi-Fi. Wi-Fi is a normal request, as well as widescreen TV. So claimant said that defendant offered also satellite TV, allowing for leasers to listen to the music. But the claimant said that you should pay us as a related right organization for using the music in public place. So the defendant said that we do not use phonograms, and the related rights are not breached concerning our short-term lease apartments, because the televisions are not equipped with a satellite connection. This issue cannot be proven, the existence of satellite or non-existence of satellite connection. But let us talk about the different sites that were used. The main issue was the following. That was dealt with for the first time, whether usage of phonograms is a part of Wi-Fi connection, and whether the smart TVs that already have all those sites can be used in short-term apartments. And the answer was the following. This was not usage of phonogram. It was based on IPO's agreement from 92, as well as from previous case law dealt with. And from that, district court actually concluded that the related rights objects could not be reached without ensuring technical possibilities. But the ensuring technical possibilities is not announcement of usage of related rights. How does that look? Providing Wi-Fi is not automatically usage of phonogram, but just the technical means to do so. The services of YouTube, free usage of that does not automatically mean usage of phonogram. Again, speaking about Netflix, it was not proven that the Netflix account could be accessed. If the leaser used its own Netflix amount on the TV screen that was equipped to do so, that does not mean that the provider provided the access to Netflix. It is logical, but there is the latest case law of the ECJ. In Emma's case, what should I say? Before that, we could conclude from conclusions, but now the criteria are rather blurred, and I cannot say what should we do in the future. It is not only my decision. Already since these 2 months since the judgment, this judgment has been criticized heavily. In order to talk about those, there should be a separate lecture on these issues. But what I conclude on these issues, if there will be the next case, we will also have to ask the ECJ for preliminary ruling. Because at the moment, there are very blurred criteria on similar cases. So let us turn to ECJ for preliminary ruling on each and every case. And if I agree to this decision, then there is one but. We are not speaking about related rights. We are not speaking about breaches of exclusive related rights, because the rights on receiving royalties are not exceptional rights for allowing or not allowing to broadcast, for example, that piece of music, but just to receive just remuneration and royalties. So this is not the breach of respective rights. Speaking about next case, I will just mention it in order for you to know that such a case existed. Basically, it is connected with broadcast organizations having public budget or public money. And how much television or radio should pay to the collective organization of royalties. Usually this invoice contains a certain percentage of income. the question, what happens with public money, with public dotations, not only dedicated for creating the content, but using the infrastructure? Is that the part of the income, thus the part of the sum that should be calculated in order to calculate the percentage paid out as royalty? So we looked at this issue from all sides, but in January we decided that yes, the dotation meant for infrastructure should also be included in the sum from which the percentage is taken to calculate the royalty. I will not explain why, but you can look at it by yourself. Another case with many laws. Maybe the Ministry of Justice will have to call a working group together, because the interim legislation was not there when the law changed, namely the absolute basics for spatial trademark. Here we don't see a symbol or a name. This is a beer box that has been registered as spatial trademark, and there was a request to ask for exhaustion of this trademark. First, because there are no specific recognition signs. This is just a beer box. It does not contain anything special. Second, if the form is necessary for reaching technical effect or efficiency. And the third basis, because the application was submitted on not based on fair grounds, that was denied. The third request was denied. The basics, this is the Carlsberg Group beer box that in 1998 was registered by Aldaris. The trademarks can be cancelled or voided. These boxes were purchased from a factory from Ukraine, and there was a dispute who can use them. But where was the problem? On technical effect. The parties agreed that this is really a beer box is a beer box, but there are, whether you can see this vertical and horizontal partition. So these partitions were looking only to one direction, and they were not connected with each other. They were kind of separate, ribbed, protruding elements, as well as ribbed sides, which are very particular for these beer boxes. Thus having a specific distinctive character. The problem is in the following. In all the IP laws, I believe, and we thought how to deal with this problem, namely legal regulation application in time. The three laws, and a law from 93 on trademark, on 99 on trademarks and geographic origin, as well as law on 2020 on trademarks. This trademark was registered in 1998. We were not in EU. We had a regulation that was only ours. Two out of the three reasons were mentioned. dishonest behavior could not be applied on that time in 1998. But the claim was submitted in 2018 already, during time when the second law was present, and the case was dealt with by the district court in 2021, when already the third law was there. They all differ, especially the first one is different. So which law should we apply? The craziest thing is that we cannot understand it from interim legislation. Our legislator has allowed for these discrepancies, but we looked at the practices of other countries. What is the ECJ case law? In Germany, there is a separate chapter, although we have several articles, and some even are contradictory. So we cannot understand which law to apply. What's the problem? The problem on distinctive characters and these criteria, as well as limitation of 5 years, which does not correspond to today's circumstances. So what our conclusions were? How we concluded? We looked at Germany, at Austria, Switzerland. Also, we looked at changes in directives. If there are separate articles in directives that has said that in these cases the countries, member states can omit to apply these requests on old trademarks. Thus, we understood that we have to apply the latest law when the claim was submitted, namely the law from 1999 on trademarks and indications of geographic origins, not the law of 1993, time when the trademark was registered, as well as not the law from 2020. So I'm not saying that it concerns all the claims and all the cases. We should look at the moment of breach of the law. There is no case law of EU. There was a case on licenses, on the timeline, whether the license was issued or whether the empowerment was given for obtaining the license. This is not the issue of IP, so we mainly looked at the empowerment and the license issuings. Not all the cases will be similar. The working group will have to sweat to look for the right solution. And I should say that not only in the law of trademarks, we have those shortcomings. Also on IP, we have some shortcomings regarding interim regulation. What else interesting we have? If in the first case we had to come up with an original solution for Latvia, how to deal with it, then in this situation we relied on ECJ or case law and IPO practice on forms as trademarks for reaching specific technical distinctive result. Usually, the defendant can say that if the technical effect can reach by the form, then it can be done with a different form. Second on distinguishability of the technical effect, an evaluation of distinctiveness. How about spatial prices, goods? Whether it corresponds to other goods, yes and no. First, we look at those spatial peculiarities concerning services and goods, and how these spatial peculiarities are perceived by the society. So it is not always immediate association with a certain trademark. If we see, let's say, a box of yogurt with a logo type or a label on it, then usually it is the logo type and the label that we associate with a certain producer, with the brand owner, but not just an object, a box or a container as such. That's why in these cases there should be a distinctive peculiarity that could be perceived as a specific distinctive characteristic function. And the last one, speaking about procedural issues, if the claim is made on the basis of three absolute basic laws, the court can have or look at the existence of one or several legal bases. It does not have to contain all three requirements. If there is one, we can decide upon it. Very briefly on this case, which was for the first time dealt with in the ECJ, we asked for a preliminary ruling on databases. And maybe Tobias will speak about databases more. Very good. Then I will briefly mention that to the directive, a new characteristics was attached by the ECJ, namely CVLV has a database of vacancies. But the defendant is an owner or of another database that is an aggregator collecting information of vacancies from other databases. Maybe the judges have not looked for vacancies very often, so you are not familiar with databases. But you, for example, know specific databases or offers of certain grocery stores, and then there are databases or offers where several prices are compared from several supermarkets, so you can immediately hit the cheapest. So it was a similar case. The CM alone offered a selection or a compilation of databases with the most suited according to specific parameters. The claimant was this one vacancy portal, CVLV. And this is the response from ECJ. I will not read it out. I tried to come up with several parts responding to this issue. I will not read it out, but what the district court decided first was erroneous, whether the claimant's database was protected by sui generis. So, sui generis or author's right. can be used in order to distinguish databases. And the response from the district court was the following. Together, the directive that was referred to by ECJ. First, what is the impetus? What are the investments to protect a database? These are the answers. What are the investments? You should scroll three different investments. First, for content or acquisition of content, but not creation of the content. Then management of the content, and then verification of the content. So there are all different kinds of investments that are quite significant, but not exhaustively significant. And this is also the decision of the ECJ, rather vague, but at the same time very characteristic. Namely that the restrictions should not be excessive. The database was protected, but the issue was whether there was a breach. And the breach occurs when, as a result of these activities, deny the income for the database owner to get profit. So, and it was proven that the profit was not denied or reacquisition of the investment due to activities of the second database owner. But you can read it by yourself. Very briefly, on the latest decision on video games. So there is a portal, Let's Play. When a person acquires a video game, plays and films and comments at the same time. This video, is it the protected work? Protected with IP rights? This was the main issue. One was not related to copyrights. Administrative court has had to decide whether these activities are commercial activities and whether this income is taxable or should be taxable. And according to the Senate, the answer was yes. But concerning copyrights, there are some related expenses that can be deducted before calculating the tax, but that is a separate issue. What is a copyright work? Namely that this was created by a person where there was a certain novelty. The district court and the regional court could not distinguish initial work from derived or derivative. If we use these two criteria, then we can distinguish them. So Senate appealed, saying that the judgment was not fair, and it should be dealt with again. The issue is the following: whether the author of the player has not breached the rights of the creator of the game. Initially, there should be a permission of the author of the initial game to come up with a derivation. In practice, there have not been such disputes. Why? Because that is quite an advertisement for the creators of the game if someone creates their own videos based on the game. But this was not related to the issue dealt with by our court. Our court dealt with the issue whether the author of the derivated video and whether this player could not be called as creator, as the author of a new work or new author's work, copyright owner.